wrote to the court on the 2nd of February, really out of a sense of growing frustration as to the way in which the local authority appeared to be formulating their plans for these children. Because what effectively happened was the original care plans were filed, which effectively recommended that the children would remain living with their mother, not obviously in Mr. Howson's home, but would remain living with their mother, as we've already heard, with no public law framework around that, and supervised contact, supervised by the mother. On the back of that care plan, quite properly, given that we have two girls aged 14 and 13, the children's solicitor and the guardian went to visit them to ascertain their wishes and feelings, and indeed to look at the potential for separate representation. The girls were very clear that they did not approve of that plan. They wished to return to their father's care. They understood their father to be well now, and therefore they couldn't understand why they couldn't go home to live with their father. They were not prepared to canvass or really consider any arrangement whereby they would be split from their younger brother Harry. The solicitor, Ms. Linden, was then giving active consideration to the need potentially for separate representation. This was on the back of the local authority's full assessment that did not recommend the children having any unsupervised contact or any care from their father. Within a matter of days, there was this strange communication that seemed to take place with certain people and not other people, the outcome of which seemed to be that the girls became aware that in fact the care plan was going to change, and in fact they were going to get their wish, which was to return to the care of their father, but that young Harry would stay with Mum. They were very pleased that they were going to go back to Dad, but they didn't want to be separated from their brother. And the mother didn't appear to know any of this and appeared to have been told by one of the children one evening after school that in fact they were going back to Dad now. That caused the mother some difficulty because of course she'd then given notice in her work, and as you've heard from Miss McNally, she's in some difficulties with her housing. All this left the guardian asking questions which were not answered, either through conversations that she was having with the social workers on the ground or that Miss Linden was trying to achieve through communication electronically with the local authority. Hence, writing to the court, saying the guardian wouldn't be ready. That's the letter I've actually just
reproduced in
yes,
yours.
Yes, because the guardian couldn't file on time. We've now been provided today with care plans that appear to go back to what was the original, but with two material differences. One, there's going to be a public law order, and two, there's going to be unsupervised contact for 2 out of the 3 children. The guardian, as we stand here now, doesn't understand, we've not been able to read or understand, and perhaps we will tomorrow when we get the statement, how the local authority have reached the conclusion that the contact can now be unsupervised. So where's the risk assessment in respect of that? Because of course the only document we've got is the local authority's full assessment that in fact talks about a high level of risk. So that, we need to understand that. However, what is of much more importance is that the guardian, I suppose, is hearing today through those representing the parents, what the parents' views are about that care plan. Mrs. Devlin would want the opportunity to go and sit down with the parents, as she has done, talk to them about the new care plans, get an understanding of what their views are about that. Then having that, because we're talking about girls aged 14 and 13, being able to then go with Miss Linden and sit down with the girls and talk to them about the care plans that we now actually have effectively in black and white. We, the three of us, anticipate that there will then be an issue about separate representation, particularly given that the girls became aware that the plan had gone from mum to dad back to mum, and are frankly very disappointed. So it's entirely likely that they're going to require separate representation from the children's guardian, which we've got very little time to facilitate and organise and file a report. There's only effectively 2 weeks, less 1 day, before we have the final hearing. And Your Honour may appreciate, although perhaps it has got slightly lost in the midst of this hearing, the girls want to speak to the court, they want to speak to the judge, and I know that we were going to...
That's a separate issue entirely.
It is. But it's the timing of that.
I think of all manner of reasons, based on what I've heard this morning, why that would not be a sensible idea in a case as fought as this one.
Quite, and we may have to revisit that with them.
Always extremely happy to meet children, particularly children of the age of Stephanie and Katie, when I've made my decision to give judgment, purposes of explaining our judgments, particularly our judgments that the children don't agree with. But as I understand the latest pilot, this care centre was agreed to undertake. The purpose of the children coming to see the judge is not to say anything that may affect the judge's decision. It's simply to give the children some sense that they are involved in the case. And I think the prospect of me meeting Stephanie and Katie and them resisting the temptation to say things which I simply couldn't ignore in the decision-making process, and it's bound to come out. And without some guidance as to what I'm meant to do about that, particularly when they're separately represented, as I will be sure they are if they strongly object to the plan, it's difficult.
Yes, and I think, Your Honour, the point at which there was some consideration of them coming to see you, and I know that Your Honour said that you were more than happy to have that happen. Of course, that was before we've had all of this unravel, and at the moment, I know that that's something that Mrs. Devlin particularly and the children's sister want to talk to them about, but they've resisted quite properly going to see these girls until they've actually got something in writing from the local authority and their parents to discuss with them. Because they had arranged to see the girls on Friday of last week, but because the planning seemed to be so confused, in fact, we took a collective decision to not see them until we knew where we were today.
Well, I'm sorry, but the more I hear about the case, the more I see this as a conflicting case. If it ends up with Stephanie and Katie being separately represented, I can't think of any better way of having them closely involved in the case than that. But my personal view is that the pilot has not been sufficiently thought through as to what the judge's role is in a case as difficult as this, because if there's no clear guidance as to what status anything the child says to the judge actually has in the decision-making process, I'm reluctant to speak to children until it's all over and I can explain what I've done.
Yes, absolutely, and I'm sure that Mrs. Devlin and Ms. Linden will appreciate that. We can talk about how that then can be communicated to the girls. The most important thing now is for the guardian to have sufficient time and opportunity to consider those care plans, ask any questions that she has arising out of them, particularly in respect of how this unsupervised contact and this shared care arrangement will come into being. We haven't looked at that and seen what that says. Have a look at the analytical statement, see what mum and dad have got to say, and then effectively take all that and go and sit down and talk with these girls in particular. is whether that can be done in a week effectively and 2 days.
What are you taking a view that it can't?
I struggle to see how it can, I have to say, and to do it properly.
Obviously, 26 weeks, so it's fine.
Well, I think
23rd of March.
yeah. It's not said lightly, because these children want resolution. They want to know what's happening to them.
We all do.
Particularly the older girls do, and indeed
Yes.
their parents do. But I think the Guardian had had this hope that, had it been managed in a much more productive way, I think she felt quite confident that she could sit down with these parents and have a dialogue as to how they arrange the future for their children. But the difficulty with that, particularly if we have contentious litigation, which on the face of it we now have, that slips away. And I think it's with great reservation that I have to stand here and say that it's difficult to see how we can embark on this. My anxiety is that we will embark, that if we do embark on it, we're just going to fall at the,
We're running into a cul-de-sac.
we do.